Good afternoon, everyone. That wasn't good enough. Good afternoon, everyone. Yeah. All right. I'm Malekzadeh, president of Roosevelt University, and I'm very pleased that you're here at the opening of Roosevelt University's second annual conference of the American Dream Reconsidered. Before we get to our program, I need to thank the people who made this conference happen the entire week to happen. So a special thank you goes to co-chairs, Professor Lynn Weiner. Lynn. All right. Professor Stuart Warner. Stuart. All right. Michael Ford. And a large group of faculty and staff who helped this week happen. And we have an amazing program for you this afternoon. Now, Roosevelt has been committed to equal educational opportunity from its founding in 1945. We have always welcomed immigrants and refugees as part of our community of students, faculty, staff, administration. In fact, Eleanor Roosevelt, the chair of our first advisory board, said, and I quote, "Somehow we must be able to show people that democracy is not about words, but action." Now, what a timely discussion to have, don't you think? All right. So this afternoon, we will hear a conversation about immigration in today's America. With Professor María Blanco, Executive Director of the Immigrant Legal Services Center at the University of California, Professor Blanco. Professor Aziz Huq, the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago, Professor Huq. And Professor Bethany Barratt, Professor of Political Science here at Roosevelt University, who teaches and does research on international law and human rights, and also directs our Joseph Laundy Human Rights Project. Is Joe Laundy here? Joe? Yeah, there you are. Joe, this is all happening because of your generosity, so thank you. Now, you will hear some really important discussion, and I'll get off the podium in 2 seconds. But just to contrast what we're talking about here, Professor Blanco is in charge of immigrant advocacy for all the campuses of University of California system, except for Berkeley. And contrast that with this past Friday, when University of North Carolina system Board of Governors barred the equivalent of Hearst Immigrant Center from civil rights litigation. So he said you can have a center for immigrant rights, but you cannot litigate on behalf of the needy and the immigrants. So keep that thought with you as we go to our discussion today. So please welcome our panel and opening our second annual conference, American Dream Reconsidered. Thank you. Stephanie?
So I'm just going to start out by giving you a little bit more of a sense of the incredible background that our two panelists bring to this discussion, because they've been working across a great diversity of issues for a very long time, and I just want to have a sense of their background coming into this conversation. So María Blanco is, as you just heard, Executive Director of the UC Immigrant Legal Services Center, which operates out of the UC Davis School of Law, but provides immigration-related legal services to all of the UC campuses with the exception of Berkeley. It was launched in 2014 and is a pilot project of the UC Office of the President. A graduate of UC Berkeley herself, Blanco has more than 20 years' experience as a litigator, an advocate for immigrant rights, women's rights, and social justice. She most recently served as Vice President of Civic Engagement at the California Community Foundation and led its immigrant integration activities. Blanco has also served as Executive Director of the Chief Justice Earl Warren Institute on Race, Ethnicity, and Diversity at the UC Berkeley School of Law, as Executive Director of the Lawyers Committee for Civil Rights of the San Francisco Bay Area, as an Equal Rights Advocates Attorney, and as Associate Director and Associate Professor at Golden Gate University School of Law, as well as National Senior Counsel for the Mexican American Legal Defense and Educational Fund. She's a member of the Public Policy Institute of California Board of Directors and the California Citizens Redistricting Commission, and served on President Barack Obama's transition team. Aziz Huq is Frank and Bernice J. Greenberg Professor of Law at the University of Chicago. Since 1998, Professor Huq has worked on human rights issues in many places overseas. In 2002, he joined the International Crisis Group as postgraduate human rights fellow from Columbia Law School, and has since worked as an analyst in Afghanistan, Pakistan, and Nepal, studying the development of legal institutions and new constitutions. His teaching and research interests include constitutional law, criminal procedure, federal courts, and legislation. His scholarship concerns the interaction of constitutional design with individual rights and liberties. Two recent pieces have respectively garnered the AALS Junior Scholars Paper Competition Award in Criminal Law and been selected for the Harvard, Stanford, Yale Junior Faculty Forum. His books include, and I think you'll love these titles, The Empire of Disgust, Prejudice, Stigma, and Discrimination in India and the US, and that's forthcoming from Oxford, or maybe it's already out, because I know it's 2017. Fantastic. Assessing Constitutional Performance, which came out from Cambridge last year, and then one whose title sounds as timely now as it was upon its 2007 release, Unchecked and Unbalanced, Presidential Power in a Time of Terror. That was from the New Press in 2007. Before joining the U of C Law School faculty, Professor Huq worked as an associate counsel and then director of the Liberty and National Security Project of the Brennan Center for Justice at the NYU School of Law, litigating cases in both the U.S. Courts of Appeals and the Supreme Court. And he clerked for Judge Robert Dusac in the U.S. Court of Appeals for the Second Circuit, and then for Justice Ruth Bader Ginsburg of the Supreme Court of the U.S. He's a 1996 summa cum laude graduate of the University of North Carolina at Chapel Hill, and a 2001 graduate of Columbia Law School, where he was awarded the John Ordino Prize. In 2015, Professor Huq received the Graduating Students Award for Teaching Excellence. So please join me again in welcoming María Blanco and Aziz Huq. We're going to start with just kind of getting our bearings, historically speaking, and we're going to start by asking Maria to provide us with a broad overview of the early history of U.S. immigration up through the middle of the 20th century.
Thank you so much, and thank you all for coming today. When we, I think, both agreed to do this, who knew what would be going on? Every time I get on a plane, by the time I land, there's literally somebody else has been fired. There's another lawsuit. These are amazing times to be in the arena of both immigration law and immigration policy and constitutional law. We are really being tested right now. So I think it is important to give a very broad overview of immigration law up to 1965, basically, which is the system we operate under now. Because if we don't, we could believe that what we see now, the sort of the restrictionist, nationalist tendency that most vividly has been expressed, I guess, maybe in the Muslim ban or with the DACA decisions, which we'll talk about later, you might think that this is new. But the truth is that if you look at the history of immigration law and policy since the origin of the country, it's consistently been one of encouraging immigration, restricting immigration, for sometimes based on facts and economics, sometimes based completely on hysteria and not factually based. And it has always had a racial element to it. And that's, so if we think that this is new, that we might find some solace in the fact that this has always been the case in the United States. So starting with the very first attempt to legislate immigration, and it was really about legislating naturalization, you had to be a free white person to be able to naturalize. That was at the very beginning. That's, 1790. Then you go on to the mid-19th century, and you have the Encouraging European Immigration Act. So the title, tells you what it was. And that primarily consisted of British, Irish, and German immigration to the United States. It follows, to some extent, industrial development and also the westward expansion and wanting to have more people populate and also work. But interestingly enough, in this period of a lot of migration, what happens on the West Coast is that you have a large Chinese immigration into California in particular. And by 1882, 25% of California was population was Chinese, which right now, Latinos are about 30-some% of California. It's in the mid-30s. So, this was way back then, 25% of one ethnic group that was not white caused the same furor that you're seeing today about in some states across the country about the changing demographics. So you have the Chinese Exclusion Act, which banned immigration completely of Chinese to the United States. And it was in effect from 1882 all the way to 1943. There was no legal Chinese immigration to the United States. And you fast forward a little bit and you get what's sort of the best known 1924 immigration law. And the reason that's so important is it was when immigration law started using quotas or caps or whatever, to regulate immigration. What was very interesting about the 1924 law is that it said that if you were coming from another country, only your numbers were limited to the 2% of the population that was in the United States of that same national origin, based on the 1890 census. So what does that mean? That who had what was the majority of the immigrant population? We just went over that. German, British, Irish. So you have this fairly explicit immigration scheme that reduces tremendously what had been a growing Southern and Eastern European migration to the United States and Asian non-Chinese immigration, Japanese in particular. So along with that, there's things that weren't laws passed by Congress that I think it's important to think of because they were immigration policy. And it shows you this push and pull. In the 1930s, you have what's called the forced deportations. It was during the Depression, and the idea was that Mexican immigrants were taking US jobs. Sound familiar? Between 500,000 and some people say up to maybe 2 million Mexicans were deported back to Mexico, 60% of them US citizens. Then you have, well, I won't go into that. And then you have, alongside this restriction, you have a Bracero program, which imports Mexican workers. So these things are sort of pulling at each other. And that goes on for, the Bracero program is from the 40s all the way to 1964. So you have the encouragement of migration while at the same time you're deporting people. And then you have, which I still find amazing that it was called this, in the 50s you have Operation Wetback. And Operation Wetback was the rounding up, increased border enforcement, interior enforcement, very much like the new executive orders we see, beefing up of Border Patrol, and the rounding up and deportation, again, of Mexicans, about 1 million persons in 1954, 1 million Mexicans. So finally in 1965, you have the family-based immigration system we have now. It was part of a whole, it took out all reference to religion, nationality, race, lifted all the exclusions. We could discuss how it still has a pretty large discriminatory impact because it caps immigration from certain regions, but that's a brief history of immigration.
So much to talk about there, and so interesting the way that everything old is kind of new again, right? In these ways that I think are sometimes hard to see given how fast the changes have been seeming to come recently. So, Aziz, I think it would be really helpful to have some idea of then the constitutional structures that have most driven and maybe been challenged by immigration policy in the US, including what Maria was talking about.
So we all know that we have a constitution that was largely written in 1788 in Philadelphia and has been in effect for more than 220 years and provides the basic framework for national government. And one might think that it's the Constitution that speaks to immigration in one of the two ways that constitutions usually regulate what government can do. It can grant powers, it can say this is something the government can do, or it can impose constraints upon those powers in terms of rights, and we're all familiar with the Bill of Rights. What is perhaps most important and most surprising about the constitutional law of immigration is that the Constitution itself is largely silent in respect to immigration. And indeed, the early history, the history from the early Republic, that is often employed as an aid in the interpretation of a constitution, also provides relatively little guidance, either with respect to the question of powers or with respect to the question of rights. And rather, what one has on both of those questions is a series of practices that have evolved over time, the meaning and the normative weight of which remain contested today. Mm-hmm. So let me take up first the question of powers. The Constitution itself does not talk about immigration outside of the clauses that pertain to congressional regulation of the slave trade. Rather, the Constitution gives to Congress the power to establish a uniform rule of naturalization. But naturalization, the question of whether and how someone can become a citizen, is not the same as the question of immigration. And as Maria said, the early Congress enacted a Naturalization Act in 1791. 1790. But by and large, ceded ground on the regulation of immigration to the states, with one exception. The one federal exception from the time that our republic was founded until the post-Civil War era is a pair of laws enacted in 1798, the Alien Enemies Act and the Alien Act. These were a package of measures enacted by the Federalist government of John Adams in response to what it saw as the emergent populist threat of Thomas Jefferson and the Republican Democrats. The Alien Enemies Act, which allows for detention of enemies of enemy aliens, people who are nationals of a government with which the United States is in a declared war with, remains on the books today. But the Aliens Act, or the Alien Friends Act, which gave the president discretion to arrest and deport any alien he saw fit to target, was the subject of tremendous popular anger at the end of the 1790s. It was subject to obloquy by Thomas Jefferson and James Madison in two famous documents called the Kentucky and the Virginia Resolutions, and was struck from the books when Thomas Jefferson came to power. And the lesson that is traditionally drawn from that history is that the president does not have wide-ranging discretion to seize and deport individuals, right? But how one interprets that history is up for grabs. So what were the states doing? Well, the states were doing a range of things up through the end of the Reconstruction era, when federal regulation really kicks in. The states were barring the poor from arriving at their ports, imposing obligations on the captains of ships to account for new immigrants, imposing head taxes, which were taxes on particular immigrants that would prohibit them from entering the state unless they could pay a certain fine or fee. They were engaging in the regulation of quarantines, something that the federal government didn't do until the 1890s, more than a decade after it started regulating Chinese immigration. And perhaps to my mind, most interestingly, and this is continuous with what Maria was saying about the role of race, the states were engaged in the prevention of the arrival of undesirable racial examples on their lands. So the best exemplar of this is a series of statutes mostly passed by southern states called the Seamen's Act. The Seamen's Act prohibited free black merchant marinemen, often employed by the British Navy, from stepping foot on southern soil, on state soil. So South Carolina, for example, passes one of these in 1823 after the Denmark-Vesey conspiracy. And these end up actually being a point of contention between the states and the federal government, because the federal government views the limitation on foreign navies arriving at US ports as an infringement upon its sovereignty. It's an example of early state-federal conflict. Starting in the 1880s, though, the federal government starts to play an increasingly dominant role with respect to immigration. We have the Chinese Exclusion Act that Maria mentioned starting in 1882, 84, 86, the Johnson-Reed Act in 1924. But the conflict between the states and the federal government, or the tension between the background state regulation and the role of the federal government in immigration remains. And we're going to talk about how that plays out today in the DACA context, right? The other conflict that's deeply unsettled still today is the relationship between Congress and the president when it comes to immigration power. And really, this is the heart of the problem or the debate in DACA, right? For reasons that we can talk about. Well, what about rights? Well, the Constitution and the Bill of Rights contain a host of rights: the rights against anti-discrimination, rights against search and seizure, rights to certain kinds of procedure if your liberty is deprived. Starting, however, in the 1880s, with a series of cases called the Chinese exclusion cases that emerged from challenges to orders barring Chinese residents and new arrivals at the border on the West Coast. Starting with the Chinese exclusion cases, the court, without any foundation in constitutional text or history, describes immigration as core to national security and a plenary power of the federal government. So in those early 1880s cases, it rejects arguments for due process, for certain kinds of procedure before somebody is deported or denied entry at the border. It rejects substantive claims based upon discrimination in the context of immigration law. The Chinese exclusion cases and the idea of a plenary power over immigration is repeatedly invoked over history by the government in its briefs to vindicate claims of unreviewable authority to extinguish the rights of non-citizens. So, for example, in the wake of World War II, there are two famous and important cases where people arriving at Ellis Island, one of them was a German war bride called Ellen Naupf. Another was a long-time Russian permanent resident of Queens called Mezai. Both individuals were denied entry, and the court, citing the Chinese exclusion cases, held that holding somebody indefinitely without any form of procedure, neither Mezai nor Naupf had anywhere to go back to, was consistent with the Constitution. Mezai and Naupf remain good law. They're cited in cases up to the 70s. There's a pair of cases in the 70s in which they are the principal authority. And those 1970s cases form the pivots of the government's brief in the travel ban cases. So that's the arc of plenary power. But at the same time, it's important to say that there's a counter-tradition. There's work by the historian Lucy Saylor showing that, notwithstanding what the Supreme Court was doing, local federal judges in San Francisco were granting many of the petitions filed by Chinese immigrants in the 1880s and 1890s. There's a series of cases starting in the early 20th century where courts, although they don't hold that the Constitution directly protects a non-citizen in the immigration context, find ways of reading the relevant statutes in utterly implausible ways so the immigrant wins. Right? So the court's trying to work its way around an unjust law as a way of, while not formally recognizing the application of the Constitution. Right? And that kind of approach to the rights of immigrants was in fact visible up until the early 2000s, a case that I worked on called Sincere, which was about the availability of judicial review for aliens subject to removal orders. The court doesn't say they have a constitutional right to it, but it finds a wildly implausible way of reading the relevant statutes to grant the aliens that right. I say it was wildly implausible, notwithstanding the fact I worked on the case. The court in recent years, though, has been willing to formally recognize the application of constitutional rights to some but not all contexts of immigration regulation. So there was a case, in fact, last Supreme Court term, written by Justice Ginsburg, in a decision written by Justice Ginsburg, that invalidated certain restrictions upon birthright citizenship because they were discriminatory on the basis of gender. And yet, the restrictive plenary power tradition remains good law. It's invoked by the government in the travel ban cases. The case, I think, that best exemplifies it is a case out of the Third Federal Circuit, which covers New Jersey, Pennsylvania, and Delaware, that holds that non-citizens arrested in the United States are not entitled to any judicial process whatsoever, citing the Mezai and the Naupf cases. And that case is a recent case on the books from a federal circuit court a few states away.
Mm-hmm. So I think so much of this kind of it gives us an idea of where some of the legal reasoning on multiple sides of the DACA decisions, right? Both the decisions taken under the Obama administration and the most recent statement by Trump at the beginning of last week, and sort of the way that some of the countersuits against that executive order have been being framed. So I think that really kind of opens us up to maybe thinking a little bit about sort of DACA and DAPA and sort of how we got here, where we might be going. That's obviously a big conversation, and we will have time for further questions at the end of this, but maybe we could just talk a little bit about where we are.
Yeah, I'll start and then, we can make it a conversation. I'll just do a brief overview of what DACA is and what DAPA was, that, never went into effect. So many people don't realize that under, up until 2014, from President Obama's first term to halfway through his second term, that administration engaged in the highest number of deportations ever by any administration in the United States. I've been asked many times what was the thinking, why this president? There are a lot of different thoughts about that wanting to look tough on enforcement was a bargaining chip for comprehensive immigration reform in Congress, but it was pretty clear at some point that that wasn't going to happen, and the record number of deportations continued. So I give you that background because DACA really comes out of that in the sense that you had no hope of a DREAM Act for the young people or of comprehensive reform, and you had incredible anger at this president's record number of deportations. And what are now known as the Dreamers, basically during President Obama's re-election campaign in 2012, took it upon themselves. They did sit-ins in his campaign offices across the country. They protested every time he went to speak. They were furious. They felt like this was the president they didn't expect this from, and these were their parents that were being deported, and sometimes their peers, not just their parents. So in the face of that, you have DACA gets announced. It's announced in June. It's June 15th, 2012. The election is November of that year. So the idea that, and when the thinking started around the DACA, which stands for Deferred Action for Childhood Arrivals, there were basically what the Dreamers said was, you, going back to your point, you, President Obama, have the right to do this without Congress. You can create a program that grants this, this relief from deportation, and with it comes authorization to work. And back and forth, there were, even at the time, there were many people saying, is this really within his authority? Is it not? Should this be limited to Congress's power? But basically, the argument that won the day was that it was a matter of prosecutorial discretion, that prosecutors, including immigration prosecutors, have the right to make decisions about priorities, about resources, who to prosecute, who not to prosecute, and that this population between ages of 15 and 30 who had been here since, before 2007, that using immigration resources to try and deport them should not be a priority, and they should be given this deferred action, which is something that immigration authorities do. The catch was that it's usually handled at an individual level. And the most famous case you always hear about is the John Lennon case, when he was allowed to remain under individual deferred action by immigration authorities in New York. So that's how DACA comes about. It basically says if you, this was in 2012, if you've been in the country since before, continuously, and before 2007, and you go and you have no significant crimes, and you've graduated from high school or you're currently enrolled in school, you pay $400, and at that time $465, and you get a biometric exam, you can apply. And they were reviewed. The dispute is about whether they were individually reviewed, each application, or whether if you met the criteria, it was a pro forma granting. So that happens. It is immediately wildly successful in the sense of people really taking advantage of it and filing their applications. And then in 2014, after failed immigration reform again, President Obama announces what was DACA 2, which lifted you no longer had to be under 30 years of age. And it says if you're the parent of somebody who's a DACA person, then you also will get deferred action, and that was DAPA. That 23 states sued to prevent DAPA and DACA 2 from going into effect. It started in a district court in Texas, made its way up to the Fifth Circuit, got to the US Supreme Court when it only had 8 members. It was a 4-4 decision, so it got basically sent. That basically keeps in place the lower court Fifth Circuit decision, which had struck down DAPA and DACA 2. So that never went into effect. And now, what's happened in the last few months, and specifically in the last week, is that now 12 attorney generals, I guess 11 now, threatened to go back to that same court and now challenge DACA because, as far as they're concerned, it is exactly the same program as the one that was struck down, and gave President either you rescind the program or we take you to court. So we saw Attorney General Sessions get up and say that they were rescinding DACA because it was a flawed legal program, that there was no executive authority to issue that DACA, and that it was in the national security interest to revoke DACA because revoking it would ensure safety against terrorism and would reduce crime. And so he's referring to the DACA recipients as potentially terrorists and criminals, and that with the rescission of DACA and their then potential deportation, this is in the national interest. Many young people lived before without DACA, but we'll see what happens. Now some states have sued, the University of California has sued about the rescission, and there is this sense of people having had this for 5 years. There's not just a sense, the truth is they turned over all their information to the government, addresses, where their parents live, where they live, and they've been working and have taken out loans because they have jobs, they've purchased homes, they've purchased automobiles, et cetera, et cetera. So we'll see that some of the cases that just got filed that sort of get at that notion of, one, could you do this? Could it just be, even though it was enacted by an order, could it be rescinded like that without advance notice, without better reasoning, without better legal, better researched and proven policy about the claim that it's in the national security interest, et cetera. And there's also, I think, going to be a lot of litigation about, if nothing else, trying to get something out of the litigation that says the information that was turned over cannot be shared, which will be, it'll always be hard to know whether, when they came for you, whether it was because they relied on information that was turned over. They haven't filed in Texas as a result of this. It's created a lot of confusion. No people can now apply for DACA, even though it was supposed to be a phase, supposed to be giving the Congress 6 months to fix it, which was the idea that this gives Congress 6 months to fix it. You could have said 6 months to fix it, but in the meantime, we continue to take applications. Not true. Applications can no longer, new applications you can't solicit for DACA anymore. And October 5th is the cutoff date for renewing it. And then after that, anybody that doesn't renew can't do so after October 5th until the March 5th cutoff, which is if Congress doesn't act, then that's supposed to be when the program finally gets reversed. Of course, the evening after the press conference by Attorney General Sessions, we had a tweet from the president that said, well, if Congress doesn't act, I may have to do something, which was fascinating because the whole basis of the Attorney General's comments were that he was rescinding this because the president didn't have the authority to do this. And then within hours, the president says that if Congress doesn't do something, he'll do something about it. Maybe you can enlighten us on that. So that's kind of where we're at with DACA. I think it'll be one interesting thing is when the case was decided in Texas, and there still is potentially a trial left in that case, but it was a preliminary injunction. The injunction against DAPA and DACA 2 was granted because it was the harm to the state of Texas was that they were going to spend a lot of money on licenses, because once you have DAPA and DACA, you can get a driver's license. And in Texas, they subsidize licenses, so having to do more subsidies created an economic harm. I think it's going to be interesting that we now have really good reports that have come out in the last few weeks about the economic contributions, not the weight, the detriment on the economy, but the contributions to the economy of having 800,000 people who can work now not in under the table marginal minimum wage jobs, but in jobs that pay more. So there's income has gone up, spending has gone up. It's inured to the benefit. I mean, there are calculations about what California has gained in taxes, New York, et cetera. So it'll be interesting to see if they did go to court, whether the same harm that the Fifth Circuit was willing to uphold in that injunction, whether that would still play out the same. But we may not this may not be a court issue. It may be all punted to Congress. So that's kind of where we're at on DACA.
Speaking of those benefits versus harms and sort of some of the, I think, myths that get thrown around, including by people who should know better, about sort of the cost-benefit analysis. There was a really wonderful study that was done by the U.S. Chamber of Commerce in 2016 that was, and actually I think it was updating a previous study that summarized, if you just search for like US Chamber of Commerce immigration myths and realities, it summarized benefits and harms in a number of different states and kind of several different academic studies, and calculated some of those benefits.
Yeah, and this is like we were saying earlier in the conversation, this is where if you study the history of immigration policy, you know that often it has nothing to do with facts. I mean, that it's not based on facts. And in fact, I have been in this policy arena for many years, and every year everybody's tempted to pull out a new report, and that this report is going to convince people that immigrants are contributing to the economy, that they don't get welfare, that they in fact contribute to Social Security and can't take out Social Security, so they're supporting, you know, people on Social Security, they're holding up the Social Security system, you know, fact after fact after fact, and it makes no difference when the debates happen in Congress. It's very frustrating. You know, you think, okay, now we're gonna get a Chamber of Commerce report. You know, that's gonna do it because that's the chamber, and it's so rooted in other reasons that it's frustrating. I have to say, it's been frustrating for years that you can't, it's never logical, it's never fact-based. There's always this undercurrent of xenophobia and of political positioning. I think it was a great report, the Chamber report. I don't know that it influenced anybody in Congress, other than those that were already kind of convinced.
Maybe if enough constituents read it and then call, or
Maybe.
you know, send enough postcards. Along these lines of flawed legal reasoning and lack of basis in fact, and failure to give prior notice, right? The other big front since January, of course, has been the travel ban. So I'm wondering if we could talk a little bit about sort of travel ban, the litigation that's been in response to it, kind of, again, how does this tie in with prior trends and prior legal structures, and where are we now and where are we going?
Right. So I think it's worth saying at the beginning that even if economic facts don't make a difference in immigration policy, and even if, as I think is the case in the context of the travel ban, facts about the risks to national security turn out to play little role, nevertheless, I think there are another kind of fact that does play a large role, and these are social facts, and facts about status and hierarchy, and facts about the relative worth of individuals based upon perceptions of their origins, their religious or ethnic affiliations, and their phenotype, their skin color. And there's, I think, a academic, I'll say this about my own academic context, there's a readiness to say, well, that kind of social fact is not real. For example, one might say race is a social construction, or something of that kind. And to my mind, that gives those social facts too little weight. It can turn out that people can act primarily upon an understanding of their own identity, which is fashioned in some kind of, for want of a better word, tribal orientation. And an explanation that sounds in those terms, which I think are facts of a sort, and this is consistent with what Maria was saying, is I think a much more powerful explanation than one that focuses upon empirical verities of the kind that social scientists are interested in. So let me say something about the travel ban and the litigation that it spawned. As many of you will know, there have been 2 travel bans enacted in this calendar year. A first ban was enacted on January the 27th, and then after that was enjoined, or which means barred, from taking effect by a federal court. A second travel ban was promulgated on March the 6th. And it's that second travel ban, which is partly enjoined at the moment, that will be the validity of that will be adjudicated by the US Supreme Court in October. And there are important continuities between the first and the second ban, but I think it's easy to lose sight of the very large differences between them, differences that I think are a consequence of the litigation that occurred challenging the ban. The first ban imposed a 90-day prohibition on the entry of persons from 7 Muslim-majority countries, Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. It also imposed a categorical indefinite prohibition on Syrian refugees and a 120-day suspension on the admission of refugees other than Syrians. And the claim was that this was a pause necessary to allow for some kind of a stop-keeping of security measures with respect to entry into the United States. The original ban was enacted on a Friday evening. It was unclear whether it applied, for example, to people of those nationalities who have US green cards, which are a legal document that entitle you to residence in the United States, for example, if your spouse is a US citizen. And indeed, on Saturday evening, the White House was telling the Department of Homeland Security, you must stop green card holders from entering into the country. And so on, I will confess a bias here. I was at O'Hare on that Saturday, sitting in the lounge of the entry of the arrival terminal at Terminal 5, the arrival hall at Terminal 5, writing a habeas petition for an Iranian couple and then in their late 70s who'd been detained since the day before in O'Hare. Not something I ever thought I would be able to say. As that story suggests, the first ban was rapidly challenged, first by the state of Washington, joined by a series of other individuals and organizations in federal courts around the country. The Western District of Washington Court was the first federal court to enter an injunction barring the operation of the first ban. That was upheld by the Ninth Circuit Court of Appeals, which is the Court of Appeals for most of the West Coast. And in the wake of that injunction, a new version of the entry ban came into effect on March the 6th. The new version is different in several important respects. But to my mind, the most important difference is in its scope. Whereas the first ban applied to basically anyone who was a national of the 7 countries, unless they were a US citizen, the revised ban applied to anyone who was a national of those countries, of 6 countries. Iraq was taken off the list when it was pointed out to the White House that we're in a war where we're actually allies with the government of Iraq. A minor detail that escaped, apparently, the experts in the National Security Council. The revised ban only applies if you don't have a green card, if you don't have a visa, and you didn't get a visa before January the 27th, right? So it applies to it basically carves out anyone who had a relationship with the a substantial relationship memorialized in the form of an immigration document with the United States. That's a consequence of the litigation that the state of Washington, the ACLU, and other organizations engaged in. That narrowing of the ban. And that narrowing, which I think was not fully appreciated in the press, was incredibly important because it cut out from the scope of the travel ban a large swathe, not everyone, but a large swathe of people who it would affect most acutely, most sharply. And that is an example of a legal victory that was won through the court. So but that is not to say that the new travel ban is all sunshine and flowers. The new travel ban has many continuities with the old travel ban, 6 countries, refugee bar, takes out the indefinite ban on Syrian refugees, has obvious and direct textual and contextual continuities between with the first ban. One of the things that attended its promulgation was an effort by both the State Department and the Department of Homeland Security to come up with some kind of empirical evidence that the 6 countries mentioned pose some distinctive threat with respect to terrorism. The State Department publicly said we're unable to find any evidence that nationals of these countries pose a higher terrorism risk than nationals of any other countries. The Department of Homeland Security reached the same conclusion, and their report was not publicly released, but was leaked, right? So the administration's own reports generated for the purpose of supporting the second travel ban demonstrate the absence of any reason to single out these countries or the nationals from these countries for prohibition on national security grounds, right? And I can talk about this evidence, which I'm sure many of you are aware, that this has more to do with religion than national security. The second travel ban was predictably challenged, both by states, this time led by Hawaii, and by private actors and organizations. The most important is one called IRAP that brought a case in Virginia. The district courts reached divergent outcomes, but 2 cases went up from the trial court to the district court to courts of appeal. The first was in the 4th Circuit, which is the case that's gone up to the Supreme Court. That's called IRAP v. Trump. The 4th Circuit sitting what lawyers call en banc, which is not in a panel of 3, but with every active judge on the 4th Circuit, which covers Virginia, North Carolina, South Carolina too, and I'm not good with other southern states, but the case comes out of Virginia. The 4th Circuit sitting en banc holds that the ban is a violation of the Establishment Clause because of the evidence of animus against Muslims as a reason for its promulgation. That is a ruling that although I think it is correct as a matter of fact and description of the world and as a matter of the law, I think is a hard pill for the Supreme Court to swallow. It's very hard for the Supreme Court to say, this is a measure that will, the president acted on the basis of unconstitutional animus. But 2 concurring judges in the 4th Circuit give what I described as statutory workarounds earlier, ways of reaching the same result, but by reading the statute. Although I actually think that the statutory readings they give are pretty plausible. So let me give you an example of one of them. The president, in promulgating the travel ban, relies upon a provision in the immigration law that says that if he finds that an alien or group of aliens would pose a threat to the national security, he's allowed to prohibit their admission. The 4th Circuit concurrence says, well, where's the finding that every national of Yemen, every national of Libya would pose a threat? There is no such finding. Indeed, the president himself, says the court, has said, we don't know if these people pose a threat. There's lots of people who don't pose a threat. Presumably the 90-year-old grandmother who is arthritic and unable to move of her own steam does not pose a threat to the national security, right? So we know that the statutory predicate for the exercise of the president's power in this case is missing, right? So that argument about the statutory authority the president has is worth paying attention to. And it's on that basis that the 9th Circuit ruled. Right? They also struck down or invalidated the executive order, the second order, but on statutory, not on constitutional grounds. So those cases have gone to the Supreme Court. As many of you will know, the Supreme Court issued a ruling in June that narrows the scope of the injunction. Basically, the court says there are certain people who have a bona fide relationship to the United States who can challenge the ban as a matter of their legal right to get into court, but there are others who don't have the legal right to get into court and therefore can't challenge the ban. And so the court says, well, for those who can get into court because they have a bona fide relationship to the United States, the injunction stays in effect. And for those who don't, the injunction now goes into, the ban now goes into effect. Now, the interesting thing about that opinion, which was issued in June, is the court says, well, the reason the order gives for the travel ban is the need for time to reassess the procedures which are used to screen nationals from these countries. Well, we're going to allow you to put most of the ban into effect, and therefore you can engage in your interagency review. And the court kind of slyly notes, by the way, notice that you said that you needed 90 days to do this interagency review. Well, the 90 days expire in September, late September, early October, pretty much just before we will hear the case. So it might be that by the time the case goes up to the Supreme Court, the court will say, well, you had your 90 days. What's the big deal? You've got what you wanted. So the case goes up to the Supreme Court in this very odd and interesting posture, where it's the court itself that has kind of engineered a situation by which it can say, yeah, there's not really a live case here anymore. Go away and do this again, and don't bother us without going through the lower courts again, which probably would take another year or so, and by which time maybe nobody would care.
So I think that when we think about sort of all the different players here, right, that it's obviously important to also bring into the conversation, especially as residents of Chicago, the way that states and municipalities and universities, right, for an event that's clearly being held in an academic setting, and thinking about the role of the academy and the American dream. And sort of how they've responded. But I also really want to open this up to conversation from, an input from you all as well. So I wonder if it'd be possible to just maybe speak briefly about kind of how localities are creating safe spaces and sort of what the most important roles have been so far and maybe moving forward, and then open things up to a few questions.
I'll start just